We'll hear argument now, number 98, 536, Tommy Olmstead versus L.C. by Jonathan Zimring.
I first met Lois when she was a teenager. I'd known her for, I'd say, almost 9 years, off and on, when we filed the Olmstead case. I sort of recognized her at the state hospital. Some social worker brought her to my attention because I don't think Lois would have thought to ask for legal assistance. But as soon as I met her and we talked, she definitely had no hesitation in saying that, as we always say, what is it that you think we could do for you? I work at legal aid and I'm a lawyer. And she'd say, get me out of here. Would you please get me out of here? When am I getting out of here? She called me Jamie right from the first day, and she could use the phone. She would call and say, Jamie, would you please get me out of here? So her request for legal assistance was very clear right from the beginning. I would say her treating physician and the psychologist, particularly at the hospital, were all frustrated that she was stuck there. At that point in Georgia, there was a program, as you know, for people with developmental disabilities with an enormously long waiting list. And if you were in a state hospital, guess what? You were not eligible. You had to be in a mental retardation hospital, and then they'd put you on the list. So that's one of the reasons they were throwing up their hands in the hospital. Social workers are saying she needs this particular program, but she's not eligible because she happens to be in the wrong place. We had a litigation director at the time, and I discussed her case with him, and he and I did some brainstorming, and concurrently with that, Steve Gold's case in Pennsylvania called Helen L. in the Third Circuit was decided. And it almost felt like a sort of a small miracle that the case that was going to be the basis for Olmstead was decided then. Helen L. was a case about a young mother in a nursing facility whose care in that facility was paid for by the Medicaid program, which is a public program, as you know. So she sued this state of Pennsylvania and said, if you're going to spend this money to keep me in a nursing home under the ADA, which requires services in the most integrated setting, you should spend that money so I can live at home with my kids.
She had seen over a long period of time, which continued in my first few years at legal aid, that people were being unnecessarily confined. And so we had a lot of discussions about how to try to deal with that. The typical approach around the country and in Georgia had been to try to bring a 14th Amendment due process claim. And those claims had been fraught with difficulty because of the high standards the courts had placed upon winning such a claim. And so that was when Sue and I started looking around at other possible ways to address the issue. One of our huge concerns was, because even when we would talk to our friends and family about it, it'd be, oh my gosh, we're going to let these people with mental disabilities out on the streets. I mean, it's not going to be safe. And so, and we knew that the state would likely make an argument that these people needed to be confined because that was the only way to treat them. And so we didn't file right away. Even though this was a problem, and we looked for some time for who we thought would be the best plaintiff. And that had its own ethical issues because there were people who needed our help, but we felt like this was going to be a test case, and in the long run, we'd be better off bringing the best case we could bring on its facts. So Sue was constantly in the hospital and seeing clients and keeping her ear to the ground, and was just invaluable in that regard. And finally, Lois came along, and then eventually Elaine as well, in which the treating physicians said they didn't need to be in the hospital. And that was the case we were looking for. So we wouldn't get into a big fight in court factually about whether they needed to be in the hospital or not. I would just focus on, why aren't you giving them the community services that they're clearly eligible for?
Our theory was that Lois and the second plaintiff who intervened shortly after we filed, that Lois and Elaine were confined in a state hospital, that the professionals, as I've said, agreed that they didn't need to be there, but they also felt that they would need appropriate services in the community. The ADA says that exactly that if you are providing services to a person with a disability, those services must be provided in the most integrated setting appropriate to the individual.
The state's first argument which was just always pretty incredible to me, was that our primary point under the ADA was segregation is discrimination per se. Just like segregating black people was discrimination, this is no different. And they tried to take the position that segregation was not discrimination because in order to show discrimination, you had to show unequal treatment. And the only way you could show unequal treatment was to show that people without disabilities were somehow treated differently from people with disabilities. But since people without disabilities weren't confined, then you couldn't really show unequal treatment. So you had to have two classes of people who were both being confined, essentially, and one being treated differently from the other, which was just unbelievable. The state's other primary arguments was that you had to be able to, that if there was a fundamental alteration of the state's program by granting the relief that you requested, the state did not have to do it. And they couched that in terms of what programs they had available, and then that led to the next step of how much they cost. And so they tried to fashion a case that it would be too expensive. And so we developed a lot of evidence that showed it was actually cheaper to treat people in the community than in an institution. And so their comeback on that, which was kind of clever, was, well, it might be cheaper to treat a particular individual, but until we have enough people to create a critical mass to be released from an institution to where we could shut down an entire ward and lay off a lot of employees, it won't be cheaper to us because we'll still be paying for the beds in the institution while we're also on top of that paying for them to be in the community. And so then we were able to come up with their own wait list and some of their own data once we dug down that showed they had 500 and some people that were eligible for community services. So they had more than enough of a critical mass, in fact, to shut down the entire hospital or a good portion of it. And so that was how we dispensed with that argument.
We filed a case. We did a huge amount of discovery because we wanted to nail down what the professionals had been saying. And we filed a motion for summary judgment, and the state filed a motion for summary judgment. And we also filed a motion for a preliminary injunction, trying to bring to the trial court's attention that the circumstances for these two individuals were critical and it was a crisis. They couldn't just live there indefinitely while courts decided esoteric claims under the ADA. They needed to get to the point. And Judge Shub, who was a wonderful and it turned out very sympathetic judge, ruled on our summary judgment motion, meaning we never did have to have a big trial to prove what the experts said and what the staff felt, and a lot of the factual issues were resolved.
Then the state appealed to the 11th Circuit, and we had the way that works is there's a 3-judge panel, and so we had Judges Joe Flatt, Barquette, and Probst sitting from another state, from Alabama, which is commonly done. So we had 2 regular members of the 11th Circuit and an outside judge filling in. And Judge Joe Flatt was the presiding judge, so he started the questioning. Not that it necessarily has to go that way. But before I get to that, the really exciting thing to me was the word had gotten out about Judge Shub's decision, and we certainly got the word out that the state was appealing it and how terrible that was, and they shouldn't be doing this, and they should just do the right thing. There's now been a decision by a federal court, and they should just do the right thing. But no, they were going to fight it to the death. And so we got the word out, and we just packed the courtroom with advocates and people with disabilities, and it was standing room only. And the judges could certainly see at that point, even though they're not supposed to be influenced by that sort of thing, right? They're supposed to make their decision based solely on the law. But they're human beings, and I think they were affected when they looked around that court.
All of a sudden, we noticed in the background this rising crescendo of advocacy, concern, and support. Again, I'll mention ADAPT because they were right there, and the P&A, Protection and Advocacy Organization, Mental Health Association of Georgia, a lot of community advocacy organizations became increasingly involved. By the time we went to the district court argument, the courtroom was full of people from those organizations, but with their help, full of individuals with disabilities and lots of people who use wheelchairs everywhere, filling the courtroom. And that happened at the 11th Circuit also.
We knew we'd probably be in trouble when we saw our panel. We thought Judge Barquette would be sort of in our corner, hopefully, and the Judge Joe Flatt would not be with us. And Judge Probst had a very conservative record in Alabama. So we didn't have the best panel at all. And it didn't help matters when, before I could even get my name out to introduce myself to the panel, Judge Joe Flatt was interrupting me and saying, and this was his loaded question, he said, "Counselor, if at some point today during your presentation, if you could just explain to me how it would not be the effect of a decision from this court in your favor that we would be throwing state officials in jail, because their defense is they can't afford to treat these people in the community, and therefore they'll be ordered to provide the services. They won't be able to do it, and you'll be bringing a contempt action, no doubt, and we will have to throw them in jail. Isn't that going to be the effect of a decision from this court in your favor?" That was the first question. I said, "Well, actually, I'll answer your question right now. The overwhelming evidence in the record, if you'll take a look at it, shows that it's actually cheaper to serve people in the community than it is in an institution. And so there shouldn't be any excuse for the state to say they can't serve people in the community, and you will not have to worry about throwing them in jail based upon that." And that was and then we went on from there. When we got done, I thought it was a 1-to-1 split. And then who knew where Judge Probst was, because he didn't ask a question, if I remember correctly. I don't think he asked one question. So no one really knew where he was. So then when it came down 3-0, we were just elated because we had an inkling they'd probably try to take it to the U.S. Supreme Court, and you're always in a better position if you have a unanimous panel than if you have a dissent. So I think we all felt really good about the fact that we'd gotten the vote of a conservative judge who seemed hostile to us during the oral argument. The Supreme Court's not required, and a lot of people don't realize this, they're not required to take an appeal except in a few exceptional circumstances, classes of cases. You have to ask for permission. And so that's called a petition for certiorari, and they petitioned for certiorari to try to get the Supreme Court to agree to take the case. And what was really disappointing to us when they did that was they had, I believe if I remember correctly, it was 22 states and the territory of Guam, of all places, joined them in seeking review by the Supreme Court. So they'd gone out and solicited all these states and said, "The sky's falling, you guys better join in with this. We're all going to get saddled with this terrible decision." And we responded and tried to argue why the court didn't need to take the case, et cetera. It was a unanimous 11th Circuit decision. The Third Circuit had ruled in our, not in our favor, but on the same issue in another case in the same way. And one of the factors the Supreme Court uses to decide whether it will take a case is whether it's a disagreement among the other appeals courts around the country that they should resolve, so it's clear to everybody what the law is. But here we had no disagreement, but they still took the case, so that wasn't a good sign. So one of the first things we did was decided we got to do something about these other states, because it really looked bad that all these states were chiming in together. And what was really disappointing was there were some states that we would never have thought of based on their history of treatment of people with disabilities, that they would want to contest this decision. And so, again, we put out the word to the network and all the disability groups that we could find and got them to lobby within their individual states to get those states to drop their joinder in the state of Georgia's appeal. And by the time, we actually started that as soon as they did their petition for cert. By the time the state of Georgia briefed the case on the merits, we'd gone down from 22 to 13. And by the time of oral argument, it was down to 5. And in fact, a few states had changed their position and were now supporting us.